I think you've all had the programme and you all know what's going to happen next within reason, but we're going to have a first session where we have a presentation by an academic, Dr. Craig Purshouse, I'm sure he'll forgive me referring to him that way, and we have 2 clinicians here who have significant medico-legal involvement who are going to talk about Montgomery. In the second half, after a short break to reconstitute the room, and it will be a short break, we're going to have a debate, and we're really looking forward to that because it'll be an opportunity to knock ideas backwards and forwards, and Anna, who's chairing the debate, will explain the rules to you in more detail. But we would encourage you, if you feel confident enough, to participate in the debate in some shape or form, because I'm sure you'll find plenty of provocative statements in the speakers to the debate we've lined up. So that's the programme. In terms of people on the live link, we have a an email connection. Unfortunately, that's not working. But Mr. Austin, who always steps into the breach, has volunteered to use his email if anyone on the live link wants to make a comment, or if they want to vote in the debate, which we would encourage them to do. So Charlie's email address, which I'm sure you all know on the live link from the many times you've instructed him, but Charlie's address is charles.austin@completecounsel.co.uk. I'll say that again, charles.austin@completecounsel.co.uk. And I would encourage people on the live link to do that. At the last event, we had a very good email thread, and it made me feel important because I felt like someone on the television when I was fielding these comments coming through from a distant place. So please do that. Okay, so let's move into the first session. And I'm going to introduce the first speaker now, who is, forgive me, Dr. Craig Purshouse. I'm going to embarrass him by saying he's a rising star in the law of tort, but he can't resist that compliment because it's true. He had a stellar undergraduate career. He got a first-class degree. He got a PhD from what I can see at about age 12. And on the back of that, he's moved forward to become a really leading academic writer. I've had to do a bit of background reading to make sure I didn't get everything wrong in my part of this seminar. And I noticed that he's referred to in academic writing all over the world. He's now present joint editor of Medical Law International, and he's also been previously on the editorial board of Medical Law Review. My first contact with Craig was when he emailed me after I'd been unsuccessful in the Court of Appeal, which happens from time to time, and he wanted a little bit more input into the case, know a bit more about it, and he said in the email, "I can't believe the Court of Appeal got something so wrong." So, where have you been all these years, Craig? Anyway, I'm sure he'll get nothing wrong at all. So our first presentation is by Dr. Craig Purshouse. Thank you.
Thank you. I'll just grab the clip. Thanks, Charles. You made me go red. I'm delighted to be here today. So I'm giving you some of the background on the area of law that we're discussing. Many of you are probably already familiar with this, but it might be a nice refresher before the debate where people are taking sides on this. I normally have 2 hours to lecture on this to students, so it's a abridged version, but hopefully I'll get through it all within half an hour. I have in my practices. So first thing to do, so we're looking at the law on how much information patients should receive before they undergo treatment. There's 2 main actions that can be brought. Action in negligence and action in battery. For a battery, it requires the intentional and direct unlawful application of force or touching of another. This will include a lot of medical treatment and surgery. There's no special defence for doctors. Instead, they have to rely on the general law, but they will be protected if the patient has consented to that treatment. So consent, it's been said in one case, Re W by a judge called Lord Donaldson, provides a flak jacket for a doctor, so protects them. However, I won't detain you too much with this area of law because in a case called Chatterton and Gerson, it said for valid consent in battery, the patient only has to be informed in broad terms of the nature of the treatment. And most doctors do that. So the vast majority of cases are brought instead in negligence, where a patient is arguing that they've not been informed of risks or side effects. So provided a patient's informed in broad terms of the nature of the treatment, there won't be an action in battery. It can happen sometimes. In the case of Chatterton and Gerson, it was mentioned that in Salford, a boy had gone for a tonsillectomy and was given a circumcision. So that sort of wrong site surgery where something goes completely wrong can found an action, but in most circumstances, doctors will be safe. So instead I'm going to focus on the law of negligence, and that will take up the rest of this half an hour slot. So if a patient's not been informed or properly advised about treatment, and then they've gone ahead with that treatment, and the inherent risks have materialised, so they've suffered some damage that they otherwise would have avoided if they'd not gone ahead, then we can say that that failure to advise the patient has caused their injury, because they would have avoided it if they were properly advised. So this could found a negligence claim, but it's quite a controversial type of claim amongst many in the medical profession, because it means even if the treatment or the surgery is performed perfectly competently, that the patient can still succeed. From the patient's perspective, though, they wouldn't have suffered that damage or harm if they had been properly informed. So to bring a claim in negligence, the claimant or the patient needs to show that they were owed a duty of care, that this duty was breached so that the defendant fell below the standard of care expected of them, and that this breach caused the damage. Now, duty of care is not normally a live issue in these types of cases, because doctors owe their patients a duty of care, and this duty encompasses diagnosis, advice, and treatment. So it's the breach or the causation issues that cause more of the problems. So I'll start with breach and the test to see whether the doctor or medical professional has met the standard of care. And for a long time, the standard of care for diagnosis, advice, and treatment was all the same test. It's sometimes called the professional practice test or peer opinion test, or famously Bolam test after this case of Bolam. The claimant in this case, Mr. Bolam, he was undergoing electroconvulsive therapy, so electroshock treatment, and he wasn't given any muscle relaxants or any restraints, and he wasn't told about the risk of fractures that could occur in this treatment. So he wasn't given these relaxants or restraints, so it's a negligent treatment case, and also a case of negligent advice. Went to court. The judge deciding this case, Mr. Justice McNair, said a doctor or medical professional won't be negligent provided they've met the standard of the reasonable doctor or the reasonable professional professing that particular skill, and provided you comply with a responsible body of professional opinion, you won't be negligent. So if you can find other peers who'd support your practice, doesn't matter if others would arrive at a different view, you won't be negligent. And that's even the case if the majority would disagree with you. So this test applied to diagnosis, treatment, and advice, all elements of the doctor's duty. So when advising a patient under this test, provided you could find other doctors who'd support your opinion, you wouldn't be negligent. Bolam was a first instance decision, but in this case called Sidaway, the House of Lords endorsed this approach with some nuances in cases of negligent advice or information non-disclosure. So the claimant, Mrs. Sidaway, she was undergoing a procedure to relieve pain in her arms and shoulders, and it was alleged that she'd not been warned about 2% risk of paraplegia. This case went up to the House of Lords. The doctor had died by the time it had reached the court, and it was all the judges in the case said she couldn't establish that this doctor had breached the duty of care. However, the judges gave slightly different opinions of the correct test in cases of information non-disclosure. So one judge, Lord Diplock, he endorsed the Bolam approach and says this determines matters. It's if you can find others who support your view, you won't be negligent. Although the doctor does have to answer any questions honestly. At the other end of the scale, a judge called Lord Scarman gave a more sort of pro-patient view. He said doctors should warn patients of material risks in treatment, and this is assessed from the position of what the reasonable patient would want to be informed of. And then the Lord Bridge, with whom Lord Keith agreed, and Lord Templeman, they gave an approach that endorsed Bolam and said it is a matter of clinical judgment. However, there might be some risks that are so obvious that a judge could say that the doctor should have warned the patient of them, even if the doctor could find others who'd support their view. So this is Bolam, but allows some role for the judge to say the doctor has been negligent. So after Sidaway, the law underwent a bit of an evolution. So initially, in the sort of late 80s, the courts just applied Lord Diplock's speech as representing the law in Sidaway and said it's the Bolam test. Gradually, over time, though, they moved away from this in a series of more patient-friendly decisions. The most notable of these is a case called Pierce, where the Court of Appeal said if there's a significant risk that would affect the judgment of the reasonable patient, then it's ordinarily the responsibility of the doctor to warn the patient of that risk. So the starting point is still what the reasonable doctor would do, but they say there's certain risks that mean that the reasonable doctor would warn the patient of them if the reasonable doctor thought the reasonable patient would want to know about them. So it's a bit convoluted, but it's moving towards a reasonable patient standard. And then in another case called Chester and Afshar, which I'll come on to later, the courts really emphasised the importance of protecting patient autonomy and patient rights. So this becomes an increasing theme as the law develops. The next big significant case is this one of Montgomery and Lanarkshire, which will be a key part of the debate later. So in this case, the claimant, Nadine Montgomery, she was pregnant and diabetic, and because she had diabetes, she was more likely to give birth to a larger baby. This carries with it, in this case it said there was a 9 to 10% risk of shoulder dystocia. This is where the baby's shoulders can get stuck in the birth canal when having a vaginal delivery. So there's a 9 to 10% risk of shoulder dystocia. However, in most cases, this can be resolved during labour, but there is a small chance that it can't be resolved, and then there's a grave risk of injuries to the child. So it is considered a medical emergency. Nadine Montgomery, she wasn't offered a caesarean section. The reason for this was the doctor had a policy of not advising diabetic patients of these risks of shoulder dystocia, because if she told diabetic patients of this risk, they'd choose the caesarean section automatically. And this can have its own risks over the vaginal delivery. And the risk of these grave complications is quite small. So the doctor had this policy, and the patient in this case wasn't informed of these risks. Unfortunately, the shoulder dystocia occurred, and the child had severe disabilities as a result. She brought a claim against the obstetrician, and this was a Scottish case. So as it went through the Scottish courts, it had failed because Pierce, the English Court of Appeal case, which had adopted the more patient-friendly approach, didn't apply in Scotland. So this case went up to the UK Supreme Court, which has decided in the law for both England and Scotland. And she was successful in the Supreme Court, and the courts changed this area of law. So the Supreme Court, in the leading judgment given by Lords Kerr and Reid, they said the defendant is under a duty to disclose the material risks to the patient, as well as reasonable alternative or variant treatments. What's a material risk? This is now decided from the perspective of the reasonable patient, or from the particular patient if there's something where the doctor should be reasonably aware that this particular patient would attach significance to it. So if there is a very small risk of being unable to sing perfectly, and they know the patient's an opera singer, that might put them on notice that this particular patient would want to know about that risk, even if most patients wouldn't be bothered. In arriving at this test, the courts said Sidaway wasn't an unqualified endorsement of Bolam. This is true, but Lord Scarman was the only one who adopted this approach, so it's quite difficult to see how they arrived at the conclusion that this is the correct approach. But Sidaway is no longer good law, and it's no longer the Bolam test that determines the standard of care in this area. They focused on the changing nature of the doctor-patient relationship. So amongst other things, they said patients are now considered consumers who have rights. They shop around and are more informed after Googling medical information. So we should treat them differently from how they were treated in a more deferential age, the more deferential age of Sidaway. They did say the risks can't necessarily be reduced to percentages, and the doctor's advisory role involves a dialogue with patients. It's not fulfilled by bombarding them with technical information. There were some caveats, so the patient could refuse to be informed of the risks if they didn't want to know about them. And also there's what's called a therapeutic exception. This used to be known as therapeutic privilege. This is the idea that the doctor can choose not to warn the patients of the risks in treatment if doing so would harm the patient. This might undercut Montgomery in a way, but they said that this shouldn't be abused, so it's quite a narrow exception. There's not much case law on how this applies. Since Montgomery, it has led to a bit of uncertainty in the law of what what doctors should disclose. These two cases illustrate it somewhat. So A in East Kent, a 1 in 1,000 risk of a chromosomal abnormality was not a material risk that needed to be disclosed. Hassel and Hillingdon, a 1 in 500 to 1 in 1,000 risk of paralysis. This was something that needed to be disclosed. I suppose it is a higher percentage risk, but it's not clear how we balance this percentages and seriousness of injury. So it does lead to some uncertainty for the medical profession. In subsequent cases, this case of Juice is quite a significant one because in this case, Lord Justice Hamblin in the Court of Appeal said Montgomery, when it comes to disclosing risks, involves a 2-stage test. The first stage is to ask what risks was this doctor aware of or should have been aware of. And this is assessed using the Bolam test, so a matter of peer opinion. So when looking at whether a doctor should have known about a particular risk, they can rely on peer opinion. So if they could find other doctors who wouldn't know about a particular risk in treatment, then the professional is not expected to disclose that risk. However, once they are aware of those risks, it's then Montgomery that determines matters, and it's the reasonable or particular patient test. So they can't rely on peer opinion. At that stage, they've got to disclose what the reasonable or particular patient would want to know. A really significant case is this case of McCulloch and Forth Valley, which was decided earlier this year. In this case, the claimant had suffered a cardiac arrest and died. He'd been discharged from hospital earlier, and his widow argued that he should have been prescribed a non-steroid anti-inflammatory drug such as ibuprofen. The defendant cardiologist in this case, her policy was she chose not to prescribe an NSAID because the patient hadn't reported that they were in any pain. So she didn't think it was clinically indicated to offer the patient ibuprofen or another painkiller. This is another Scottish case, but it went up to the UK Supreme Court. And the issue here was, should the cardiologist have offered this alternative, and what determines what counts as a reasonable alternative? So Montgomery had decided that patients should be warned of material risks and reasonable alternatives. The test for the risks was from the patient perspective. Is the test for what counts as a reasonable alternative determined by professional practice and the Bolam test, or is that too determined by what the reasonable patient would want to know? In the UK Supreme Court, Lord Hamblin and Lord Burrows said the correct approach for what alternative treatment should be proposed is the Bolam test, so it's determined by professional practice. So the defendant doctor won't be negligent just for failing to disclose possible treatments if they don't think those treatments are clinically indicated. So the doctor will look at the possible alternative treatments, select the ones that they see as reasonable or clinically indicated, and offer that selection to the patient. They don't have to offer them all treatments or all possible treatments if they don't think that they're clinically indicated. This was decided by the UK Supreme Court in a Scottish case, but also earlier this year in a case called Bilal and St George's, the England and Wales Court of Appeal arrived at the same conclusion when the same issue was before the courts. McCulloch, though, does create some tensions with Montgomery for a number of reasons. The reasoning in the case is not necessarily consistent with that of Montgomery. So one reason given was that if it was decided by if the doctor had to give the patient all possible treatments, this would be bombarding the patient with information. Likewise, they said it can lead to uncertainty for doctors if they didn't know which treatments to offer and weren't able to rely on clinical practice. And so this creates a bit of tension with Montgomery, because you could say the same about risks, that warning the patients about small risks is bombarding the patient with information, and that this also, Montgomery creates uncertainty for patients. So the decision arguably is consistent with Montgomery, because Montgomery didn't actually clarify what counts as reasonable alternatives, but the reasoning, there is some tension there. So even if the patient can establish that the doctors fell below the standard of care and breached the duty of care, that's not enough to succeed in a claim in negligence. They've got to show that this breach or the failure to disclose this information has caused the damage or injury. So the patient's got to have suffered some form of injury, so the surgery or procedure has got to have resulted in some harm to the patient, and this harm has to be a result of the failure to warn. So this normally means establishing that the patient, if they'd been properly warned, wouldn't have gone ahead with the procedure in question. Because if the patient would have consented anyway, then it's not the failure to warn that's caused the injury, it's just the inherent risk in the procedure, and they wouldn't have avoided those risks if they'd been properly warned. So the test in this area for causation, like the rest of the law of negligence, is the but-for test. So but for the defendant's breach of duty, would the claimant still have suffered the harm? So you take out the breach and look, would they still have suffered the harm in any event? In a case called Jones and Northwest, this illustrates this. So here, the defendant breached their duty of care in not offering the claimant a caesarean, but it was found that this particular patient, even if they'd been offered this, and so even if the doctor hadn't breached their duty of care, that this patient would not have chosen the caesarean, because this patient is a Jehovah's Witness. Jehovah's Witnesses see reception of blood products as contrary to their religious beliefs. So as a caesarean carries an increased risk of a blood transfusion, this patient probably would have chosen the vaginal delivery in any event. So here, even if there was a failure to warn and offer the caesarean, it was held, the patient wouldn't have chosen this option anyway, so the claim failed. Problem with this type of case, though, is the patient, after they've suffered the harm, now has the benefit of hindsight, so is going to look back at their choice to undergo that procedure quite negatively, and also they will not get any compensation if they say, oh, I would have acted in the same way. So there's a lot of incentives with the benefit of hindsight for the patient to say they wouldn't have undergone the treatment. To resolve this, the courts in a case called Smith, Barking, Havering and Brentwood have said the courts should look at what the reasonable patient would do in these particular circumstances. And if the reasonable patient would have gone ahead with the treatment, then the claimant has to show that they would have acted differently from this reasonable patient. So creates a bit of a presumption. Now, it's possible for the patient to do this in a case called Birch. The claimant in that case managed to convince the judge that she wouldn't have undergone the particular treatment. In other cases, the patient's not able to do this. It's attracted some academic criticism, this test, because some academics have said, well, why does it matter what the reasonable patient would do if this particular patient wouldn't have gone ahead with it? I think this criticism, though, is quite misguided because the burden of proof is on the claimant to bring in their case and to prove their case. So if the claimant is arguing that they would have acted in an idiosyncratic manner, then they have to convince the court that that's the case. So this just seems to be following normal tort principles, in my view. And it may be possible for patients in a number of cases to convince the court. If we think of the Jones case, which I discussed on the previous slide, and reverse that, we might say, well, if the reasonable patient would undergo a caesarean, this patient who's a Jehovah's Witness might be able to convince the court quite easily that they wouldn't have. And it is just a matter of the judge believing the claimant's be more persuaded by the claimant's evidence ultimately. Case that creates problems, though, is this one of Chester and Afshar. This is was quite a contentious case. It seems to have been more confined to its facts in recent years. So this case was one where Miss Chester, the claimant, she had back pain and was considering undergoing surgery. She wasn't told about 1 to 2% risk of paralysis. The defendant, Dr. Afshar, had said when she asked about the risks, he said he'd not paralysed anyone yet. So hadn't warned her of this 1 to 2% risk of cauda equina syndrome that's associated with this spinal surgery. Unfortunately, these risks eventuated when she underwent the surgery, and she brought a claim in negligence against him. However, she didn't argue that she never would have undergone the procedure. She argued instead that she might have sought a second opinion and might have undergone it at a later date. So she couldn't argue that she would have completely avoided these risks eventuating. This went to House of Lords, which was divided upon whether she could succeed or not. Two dissenting judges thought the claim should fail. The majority allowed her to succeed. However, even in the majority, they acknowledged that this doesn't fit with normal causation principles. Instead, they thought these normal principles should be departed from in order to protect her autonomy and rights to decide what treatment she should have. So this case is a departure from the general principles. However, the courts have been very reluctant to extend the case, and in a number of decisions they've confined it to its facts. Also, because the courts emphasised the patient's rights to autonomy, it led to some academics believing that this area of law just protects a right to autonomy and that patients might not have to show that they've suffered any injury or damage as a result of the failure to warn. However, the Court of Appeal in the case of Shaw and Kovac said, no, you still need to show actionable damage. Loss of autonomy is not the interest that this area of law protects. Hopefully I've stuck to time, but that finishes my talk. Thank you.
What is the time? Is it right, Ken? Well, thank you very much, Craig. Well, you've obviously thought about this before. You seem to know quite a lot about it. That's a really excellent start to our seminar. We're now going to have two clinicians speak, one by one, I should hasten to add. And we're going to start with Jonathan Hobson, who you can see has just stood up next to me. And Jonathan's an ENT stroke thyroid surgeon at Wythenshawe Hospital. He's the lead thyroid surgeon there, and he's also been clinical director of specialist surgery in theatres in Wythenshawe, and he also has a significant medical legal practice involving clinical negligence and also more mundane matters such as noise-induced hearing loss and tinnitus. But I think he's admirably qualified to speak from the hospital perspective. Thank you, Jonathan.
Great. Well, thanks very much for that introduction, and thank you for having me over from Manchester to your wonderful city. I'm a big fan of coming over to Liverpool, and obviously the talk today is Montgomery and how that affects or my experience of Montgomery in ENT. So of course the first thing I do whenever I have to do a talk is to Google it, or at least I did up until this year, and obviously now I just stick it straight into AI. I should say that all the slides are my own apart from one, and I'll see if you can guess which is the AI generated one. But the first thing I saw when I Googled Montgomery and ENT was this lovely practice in Indiana in America, the Montgomery ENT Center, and as a trainee reconstructing narrowed tracheas in neonates, we used to use these things called Montgomery T-tubes, and these children would be on the ward breathing and struggling, and Montgomery and ENT brings back some memories of those forlorn nights. But of course what I'm here to talk about is the cases that Dr. Purshouse has, the case of Montgomery versus Lanarkshire, and how that affects my day-to-day life in terms of seeing patients in clinic, consenting patients, and having a discussion with patients about whether or not they should go ahead with surgery. And so, of course, this is the relevant paragraph, which I don't need to dwell on in any further detail. But what I will go on to say is to ask the question, has Montgomery changed our consent process? Well, the quick and trite answer to that is no, because prior to Montgomery, we were discussing with patients what their views and wishes and expectations were and what they wanted and how it affected them. Probably we weren't in depth. And so the actual answer is yes, maybe it has, but I don't think it has to an enormous extent, because I think Montgomery is more of an evolution of surgical and clinical practice. As Dr. Purshouse was mentioning, that the patient in 2023 or whichever year it was at Montgomery, 2012 I think it was, wasn't it? It was 2015. Is a very different patient to the patient in 1970 or 1980 or what have you. And so what do we do in ENT? Well, it's surgery of the ears, the nose and the throat, or as one of my nieces once said, that surgery of the ears, nose and tonsil. Many people have had their tonsils taken out, but it's ears, nose and throat. And a lot of what it is improving people's quality of life by, opening up blockages, opening up, allowing you to swallow, allowing you to hear, allowing you to breathe, and avoiding damage to nerves and special senses. So ears, seeing, smelling, hearing and all the rest of it, all the special senses affect ENT. And I thought I'd just go through a sort of sort of car crash of slides of things that can go wrong. So if I'm operating on a nose, this is the I've got a laser. We haven't got a laser pointer. I don't think we've got a laser pointer. If I have got a laser pointer, I'm probably pointing it, blinding the. Sorry, I am. It's exactly what I'm doing. Anyway, this is the nose. These are the eyes. This is the brain. The nerves of the sense of smell are right at the top there. So if you operate on the nose, you can lose your sense of smell. If you operate as well in the nose, doing what we call endoscopic sinus surgery, the eyes are not a million miles away from the nose and the base of the brain, so it's possible to cause damage to the eyes, orbital injury. It's possible with our instruments to remove not just nasal polyps, but bits of optic nerve, and this patient's got a very large hematoma in their left eye there, and so we can cause blindness. Now, just interesting, I was at a conference in America earlier on in the year, and I went to a couple of medico-legal talks at that conference. And this is just a sort of food for thought, really. There was a case where someone had had endoscopic nasal surgery, sinus surgery, and they had had some packing put into their nose, and some steroids were placed into that pack. And the steroid was absorbed into the orbital artery and had blocked the orbital artery and caused blindness. And so this patient litigated for blindness. Now, blindness as a result of steroid insertion hadn't been discussed on the consent form, but death had been. And the defendant, litigator, lawyer, whatever the phrase is in the States, had said, well, so talking earlier on about would you have had the operation had you known about the risks, the defendant litigator said, well, you consented to have this operation knowing that you could die, and you've only gone blind. So, I mean, that's not as bad as death. So even if you'd known you'd have gone blind, you'd still have gone ahead with the surgery. And I've never really heard that as an argument, but to me it seems kind of difficult to argue again. If you're happy to sign up to death, and perhaps we can talk about that perhaps we can talk about that later. If you're happy to sign up to death, why on earth would you not go? Would you not be settled or be happy for a spot of blindness? Anyway, have I missed a couple? The facial nerve. So the facial nerve is the nerve that supplies all of the muscles of facial expression, and it starts off in the brain, it passes through the ear, and then it comes out on the side of the face. And if that nerve is damaged or injured, you can have a facial paralysis, which is a facial droop, which looks very similar to what patients have who have had a stroke. As I say, the nerve passes through the ear. There's a little branch of it that goes off to the tongue, and so anyone who has ear surgery can be left with facial paralysis or taste disturbance. Taste disturbance. And then when we're operating on the ear, you can destroy or damage the organs and nerves of hearing and balance, and you can destroy the nerves of hearing, and you can end up with a dead ear, or you can end up with reduced hearing or buzzing noises, tinnitus or vertigo. When I'm doing thyroid surgery, there's a nerve that runs through the neck and goes under the collarbone and back up just behind the thyroid, which is called the recurrent laryngeal nerve, and that's the nerve that supplies the muscles to the voice box. And the first step of thyroid surgery is to identify that nerve and avoid damage or injury to it. But if that nerve is damaged or injured, you can be left with hoarseness, which can be temporary or permanent. And in fact, if you do a total thyroidectomy, take both sides of the thyroid out, and both of those nerves were to be injured, then you can be left with vocal cords that don't open, which causes difficulty breathing, and you need to have potentially a tracheostomy or a breathing tube placed in. And then just coming up to the end of some of the nerves that we can and do and have damaged, there's the accessory nerve, which goes across the shoulder or across the neck and into the shoulder, and it's very easy. It's quite a superficial nerve. It's very easy when you're taking out small lymph nodes for biopsies to damage or injure that. And of course, having a dysfunctional shoulder can be a very problematic injury dependent on your occupation and whether I have once been asked to give an opinion in a case for someone who was a tree surgeon, and of course they couldn't lift their arm up above their head and could no longer be a tree surgeon, and it was a large case with subsequent loss of income as a result of that. So a lot of what we do, obviously there's a lot in ENT, things that we can mess up, things that we can damage and things that we can injure. And I think it helps when I'm consenting a patient to work out why that patient is in front of me, what they want, and if I can say it, what they need. I don't say that in a paternalistic manner, but why are they having an operation? And so I've split this table into things that we do in ENT which are for your quality of life and things that are life or limb threatening. So if a patient comes to me with a thyroid cancer, to a large extent, although thyroid cancer is extremely treatable and very curable, which is fantastic, but to a large extent, if we don't treat that thyroid cancer, you might die from it, or die of it rather. And that's very different. Someone who's got a thyroid lump that's the size of a tangerine or a satsuma, and every time they swallow, it's a bit uncomfortable, and perhaps you've got a little bit of shortness of breath and you're struggling walking up a set of stairs or a flight of stairs. But there's a big difference there. So the thyroid cancer, the patient probably almost certainly is going to have that operation, whereas a thyroid lump, it's more about weighing up the pros and cons. Similarly, if a patient has a sinonasal malignancy, which is quite uncommon, but we do see nasal cancers, they're likely to need to have an operation for that, as opposed to someone who's got some nasal polyps, who sits on their sofa and snorts and sniffles a little bit and annoys their spouse, but isn't particularly bothered by having a blocked nose. Similarly, if someone has sinus infections that travel up to the eyes or the forehead and cause, and they've had sort of orbital abscesses as a result of sinus infections, that's significantly worse than having nasal polyps. Someone who's got an ear disease, something called a cholesteatoma, which is the skin of the eardrum growing inwards into the ear and potentially eroding the bones of hearing, potentially causing damage to the nerves of hearing. In fact, Oscar Wilde, going way, way, way back when, Oscar Wilde's father was a very famous ear surgeon. And the irony is Oscar Wilde had a cholesteatoma and I think died of a cerebral cranial abscess as a complication of a cholesteatoma. Much less common in the 21st century than they were previously, but we still do see people who have, people still die of cholesteatomas that are left untreated. So ear surgery for a cholesteatoma is a very different ballgame for ear surgery for someone who's got something called otosclerosis, for example, which is a condition where the bones of hearing don't move and articulate as well as they should do. And having an ear operation, it restores your hearing, but you could have your hearing restored simply by using a hearing aid, which of course has its pros and cons, but doesn't involve the risks of surgery. And then, do we take out someone's tonsils because we're worried that they have a tonsil cancer versus, some episodes of tonsillitis and some days off work. So I think in terms of the consent process, it's very clear cut when you're doing it, I think, for life-saving procedures. We mentioned earlier on Jehovah's Witnesses, and there are some conditions where a Jehovah's Witness might say, I don't want this surgery because it will involve blood products. But of course, there are ways to mitigate that: cell savers, auto-transfusion for a select group of patients. But there are some patients who have quite advanced cancers who may decide that they don't want to have surgery because they think it's futile, and that's obviously a slightly different group. For the majority of people who've got a potentially treatable life-saving condition, I think the consent process is pretty straightforward. Yes, I've mentioned futility of surgery in advanced disease, and a small number of patients are terrified of surgery and have capacity to decline it or not want to have it, but that's fairly rare. But this is the area where I think consent is difficult. So I talk about it as a seesaw with my patients. So it's those patients who are having surgery to improve their quality of life. And, these are patients who I say, well, this is the risk of surgery, and this is it's painful, you can have these complications, and this is how you are by having a constantly blocked nose or not being able to hear. And sometimes the seesaw will swing that way, and patients decide they want to go ahead with an operation. And sometimes the surgery will swing that way, and patients will decide that they don't want to. And sometimes, as a clinician or as a surgeon, we sit on the seesaw and make it swing one way or another. And sometimes it's difficult to know how best to approach the seesaw without making it tip in one way or the other. A question I was asked to address in terms of this talk as well is how practical is Montgomery? I think in general it's okay. We don't have infinite amount of time to speak to patients, but our clinics, certainly in surgery, are designed so that we have a reasonable amount of time. And someone who's having an operation will almost certainly have a much longer consultation than somebody who's come to have a brief discussion about their scan results, which are normal, for example. And so I think in general terms, for most of the things that we do, there is adequate time to talk to patients, to find out what their hopes and fears and expectations are, to find out what their occupations and hobbies and whether surgery is likely to cause any particular problem for that patient in front of you as opposed to 100 other average patients. But of course there are certain specific patients. So on the left side of the screen, this is just a Google image of a sommelier. If you're operating on a sommelier's nose, that's going to be a little bit more important, I suppose, than operating on someone who doesn't have a professional job that involves smelling and aromas and whatnot. In an homage to coming over to Liverpool, the picture on the left-hand side is someone called Jennifer Johnson, who's a mezzo-soprano who was at the Liverpool Philharmonic. It's someone I was at university with, and she's known on all her socials as the Scouse Diva. So that was my opera singer picture. It was almost as if you had read my slides. So obviously, if you're doing vocal surgery or voice surgery on a singer or an opera singer, that's much more specific and concerning than someone who doesn't talk at all. And I'm afraid I couldn't bring myself to put a picture of someone wearing red on the slide, no matter how deferential I was. So I just put a picture of Erling Haaland on, the finest striker in the land. But I've had professional sports people who have had professional football players who've got hay fever. And the operation that you do is pretty straightforward, but you're talking in terms of an operation that's going to put them out of training for a potential length of time. And the risk might not be with the ENT bit of the operation, the risk might be with all of the rest of their training and programs and whatnot. So obviously there are particular patients. Has Montgomery encouraged defensive medicine, I'm not sure it particularly has in any sort of a jump. I think probably defensive medicine has become a bit more evolutionary. But certainly we have a greater level of discussion, I think, with our patients. I don't think we operate in a different way or refuse operations or are more likely to do operations as a result of Montgomery. And then just coming to the end of the talk, I just wanted to talk in terms of how does Montgomery fit in with the sort of pillars of medical ethics, which are obviously autonomy, which we've spoken about previously, respect for patients' rights, self-determination, and beneficence, doing good, non-maleficence, don't do bad, and justice, which is to treat all people equally and equitably. And I think actually, if it does anything, it probably doesn't, it sort of ticks the first three boxes, but it perhaps doesn't tick the last one, because we have to make sort of assumptions with patients, and we do sometimes make assumptions on patients' behalf, which, in spite of all the knowledge we have about that individual in front of us, may or may not be the correct assumption. And I just wanted to give an example of that with a couple of scenarios. These can be either two separate patients or the same patient on the first day. So this is someone whose mouth is open. You can see this tonsil's a little bit bigger than the one on the other side. They might have, there's a little white spot, is a little tonsil stone. No one knew what tonsil stones were 20 years ago. People would come and have these little smelly white dots in their mouth and think they were cancers because, if you read a paper, it says if you've got something that doesn't look normal, go and see your doctor. But now with, YouTube and Mr. Pimple Popper and Mr. Tonsil Stone, I think everyone knows what a tonsil stone is. But, we'll get patients who come and see me and say, I've got these tonsil stones and one tonsil's a bit bigger. And one day I might say to them, well, the little white spots, they're a bit smelly, they're a bit annoying, but you can get them out. Don't use a paper clip to get them out because that can make it bleed, but they're nothing to worry about. You probably can't smell them. Yes, one of your tonsils is a little bit bigger than the other, but it looks entirely fine. If we did an operation, we take your tonsils out. It's really painful for 2 weeks. You could bleed. About one person every 5 years in the UK dies of tonsil surgery. Obviously, surgery could be life-threatening. You could lose your sense of taste, and you can chip and injure your teeth. And that patient's likely to walk out and say, I'll just leave my tonsils alone. As opposed to the next patient, or the same patient on a different day, entirely identical scenario, and I'll say to them, your right tonsil's larger than the left. I don't know what it is. It could be a cancer. We don't know until we take it out. I think we'll bring you in for an operation. It's pretty straightforward. We do hundreds of these operations a year. It's a bit sore, but we'll give you pain-killing medicines. There are risks of bleeding, infection, chipping and injuring your teeth or taste disturbance, but they're all really rare. It's pretty straightforward, and you should be back in terms, in work in a couple of weeks. There are risks, but they're not zero. Now, that's the same patient. Similar conversation. I've said the same risks in each scenario. I've just said them a little bit differently. And I think this is something that, on a practical point of view, as an ENT surgeon, we realise that consent is very different when you do it on a day-to-day basis than I think you perhaps think of it from a legal perspective, because in both of those scenarios, it's condensed just for the purpose of the talk, but I've mentioned the same risks, but I've just done it in a slightly different way. And so, in terms of that seesaw, on the first case I was sitting on that side of the seesaw, and on the second case I was sitting on that side of the seesaw. And really, I think we just have to be very wary with consent, because just like, Darren Brown, who says, what was the word that you thought of earlier on that I've written in the envelope? Sometimes when the patient comes in, what word or what envelope they're going to choose. And that's not, I'm not saying that that's us as surgeons pointing people in one way or another, but sometimes the conversation you have sways people one way or another. And just another thought I was having, but I haven't included it in the slide, is there is a condition called vestibular schwannoma, or an acoustic neuroma, which is a benign enlargement of the nerves of hearing and balance that you can present in patients who have single-sided deafness or tinnitus or vertigo, and we'll often remove those. Now, I've worked in a unit before in the Northwest where that procedure was done by ENT surgeons. And I've worked in another unit in a similar region where it was done by neurosurgeons. And I say this as an example, but in no means wishing to be derogatory or rude to any particular surgical speciality. But neurosurgeons spend most of their time dealing with patients who have life-threatening intracranial procedures where, on a daily basis, they see patients who have strokes, who die during surgery and have catastrophic outcomes. honestly, I don't mean this as aren't ENT surgeons fantastic. It's really just to paint the picture. ENT surgeons, on the other hand, from what I was saying in my talk, we take it, most of the operations we do, if a patient has a minor neurological adverse outcome, it's a bit of a disaster. So if you're a neurosurgeon and you do this operation and someone wakes up with a facial nerve palsy, you may just think to yourself, well, they've not had a stroke, they've not had a catastrophic brain bleed, they've not died. Whereas if you're an ENT surgeon, you may think slightly differently. And so I think consent comes not just to the patient, but it also is dependent on the procedure and what you're used to dealing with on a day-to-day basis. And that more or less wraps up my talk, apart from the final slide, which was when I said to AI, please can you draw me a picture of an ENT surgeon taking consent? And 30 seconds later, I've got that. I mean, I don't know what that is. That's a sort of microscope. That's pretty much what the ear looks like. But so I don't think any of us will be taking consent in 20 years. This is all irrelevant because in 20 years' time there'll be, AI derived consent forms. But thank you very much for your time.
Well, thank you, Jonathan. I'm sure we'd agree to whatever you recommended us to do based on that. That's great. Right, we'll move on to the next speaker, if we can. I think it's very warm in here, but I think it's getting a bit better with those doors open. Is that right? Yeah. Okay. Sorry about that. Not my fault. Why am I apologising? Anyway, the next speaker is Dr. Simon Minkoff, who is trained in anaesthetics, but is now what I think I can call a frontline GP in Manchester, which must give him particular interest in consent and discussing matters with patient. He describes himself, this isn't my expression, but he describes himself in his CV as someone who's involved in medico-political affairs. I'm not quite sure what that is, but he can possibly explain to us at the bar later. But I think particularly in that context, he's an active member of the BMA, and very appropriately for this evening's presentation, he's chair of the BMA's Medico-Legal Committee. So, Dr. Minkoff, please.
Okay, thank you. Thanks, Craig, and thanks, Jonathan, for being the warm-up act. I'm going to give you a bit of a brief overview about Montgomery from a perspective as a GP. Like Jonathan, I've travelled from Manchester today. I actually sometimes work a few doors down the road here in Liverpool, and my wife is a Liverpool graduate, so likewise, it's an absolute pleasure to be in Liverpool today. My CV, you might not see it too much in the back, don't worry, the words I say will add to what's on the screen, but I graduated 25 years ago, so I am starting to feel a little bit middle-aged. I graduated in Manchester. I trained in anaesthesia originally, so lots and lots of what Jonathan's been saying is a reminder of what I used to do. 4,000 to 5,000 patients, never chipped a tooth once. So the 1 in 1,000 risk, maybe they don't need to be telling patients that anymore. But I left anaesthetic training in 2008 to become a GP, and once I graduated as a GP, my GP career involved something called inclusion healthcare, which is looking after patients who are homeless or at risk of homelessness. They often have something called a dual diagnosis, which is having both an addiction and a psychotic illness. And they were often survivors of adverse childhood events. Quite an interesting job. At the same time, I was also working as a GP in an incredibly affluent part of northwest London. We had patients who were very well off financially or academically. I had lords, ladies, professors, very, very senior judges, celebrities, etc. So two ends of a massive, massive divide. And then I moved up to Manchester with my family for a new partnership in a practice that was very, very diverse, just not quite as diverse. 2019, I needed to leave the partnership, a little bit of a lack of confidence in my partners. And then, of course, COVID happened. And during COVID, I spent a few years working for the National Coronavirus Clinical Assessment Service. I was part of the clinical audit team, and I led the clinical safety review panels. We had about 2,000 doctors working for the service, 2,000 GPs working for the service. So I was probably involved in the clinical review of the biggest team of GPs in the country. I still do some GP work. I work as a locum, I work in the NHS, and I work privately, and I do a load of other things as well. I hold a tribunals appointment, so I'm technically a member of His Majesty's Judiciary. I'm a medical examiner, so I review, scrutinise medical records before issuing a death certificate or referring to the coroner. And also, as said, I've been doing lots and lots of BMA work for most of the past 25 years, but not all of them, and currently have the honour of being the chair of the Medical Legal Committee. Don't worry if you can't read the words, it's not about what the words say. So in thinking about the fundamental question of how has Montgomery changed our practice, obviously as a GP, I'm not talking about providing consent for a procedure, but there are other ways in which we're thinking about consent to patients. But I can give you a bit of a tour of those past 25 years, which very much correlates with what Jonathan was saying about how consent is given. And I think, first of all, if we go back before 25 years, consent was very much a practice where once upon a time the junior doctor would go up to the patient the night before the surgery and say, you know you're having your tonsils out, do you want to sign the form, please? And that would be consent. And it was a thoroughly inadequate process. I think we all know that. 1999, I became a house officer. I was working in cardiology, and I was still the doctor who had to go and get the consent. But I remember having the red A4 file with the laminated cards sitting behind the nursing station. Why? I remembered when I was writing this talk that it was a red file, I don't know, but it was very, very significant. But this file contained a laminated card for each procedure I might be consenting the patient for. And it was quite surprising at the time because I was required to say to my patients, there's a 1 in 100, 1 in 200 chance that you might have a cardiac arrest whilst you're having your procedure, or you might die whilst having the procedure. Do you still want to sign the form? But consent was clearly moving on. And then I moved into anaesthetics. One of the things that I would be consenting for in anaesthesia would be for epidurals, particularly in labouring women. Epidurals, the only thing that actually takes away the pain of childbirth, which is probably one of the two worst pains we have. It's that and trigeminal neuralgia. We would be consenting for epidurals. And certainly I recall that in consenting for an epidural, I would be telling my patients that there is a risk, about 1 in 100, 1 in 200, that you might get a post-dural puncture headache. Getting a headache due to an epidural after you've delivered your baby and you are bedbound for a few days is probably the worst thing you can have. So it's really significant. And we'd also be describing it as about a 1 in 1,000 chance, that magic number you gave Craig earlier, 1 in 1,000, about a 1 in 1,000 chance of an epidural abscess, an infection in the epidural space that, if left untreated, may extend and get worse and may cause permanent nerve injury. So we were, back then, early noughties, already thinking about what sorts of risks, what sort of significant risks in terms of the severity, but not common risks. But I thought to myself, I need to give you some more information, not just some anecdotes. So 3 different books that I've pulled off my bookshelf from when I started doing general practice. So I've left all the hospital stuff now. We're talking about general practice. Pendleton. If you speak to GPs, GP trainees, and talk to them about consultations, they're typically going to mention Pendleton or Neighbour. Pendleton's second book, The New Consultation, I don't know what the old book was called. It wasn't called The Old Consultation. But he's got a page in there about consent, and there's an incredibly illegible 3 paragraphs on that. I don't need to tell you too much about it, other than to say it's talking about Sidaway, and it's talking about Lord Scarman. So my warm-up act has very kindly done all the hard work on that one. But 2003... new GPs are already being told you might want to think about some of the other risks. 2003. My GP trainer was a big fan on this book. I think there's only 2 copies of this book in the country. He's got one and I've got the other. Big book, much thicker. it's kind of a Bible of what do you need to know if you're about to do something and you're not quite clear. And again, don't worry that you can't read it, but over the spine of the book, there's these 2 columns of lots and lots of bullet points about how to give a vaccination, things to think about when giving a vaccination. One of those bullet points is about consent. And what it says is if you're going to be consenting for vaccination, warn them of a risk that they might get fever or pain and they might want to take some paracetamol or ibuprofen. That's it. There's nothing in there about the risk of anaphylaxis, allergy, which can be life-threatening. In consent, it does say that you shouldn't give it. You shouldn't give a vaccination if they're likely to get an anaphylactic reaction, but you don't know if they are or aren't. So there's nothing in there about consenting for the risk of anaphylaxis. And there's nothing in there about the benefits of vaccination. Why are you coming in here for the vaccine? So all the benefits about whether it be herd immunity, whether it be reduced sickness, reduced absence from school or work, reduced risk of turning up in hospital, needing to be admitted to hospital, going to intensive care, having a long-term disability or dying from the vaccination, none of that is in the whole consent process advised in this book. 2010, pre-Montgomery. But there's nothing like a difference of opinion, is there? The Oxford Handbook of General Practice, anyone who knows anyone who is a reasonably young doctor might be aware of one of the Oxford Handbooks. I think most medical students, certainly in the 90s and noughties, would have had the Oxford Handbook of Clinical Medicine, and then they've got a whole range of them that happened since. But the Oxford Handbook of General Practice got me through my GP training. If it wasn't in that book, I didn't need to know it. 1.5 pages on consent. Again, you don't need to worry about what it says in the little writing, but basically in all the little writing about consent, it says, this one I'm going to have to read for you, sorry, because it's quite good. Same time as the other book. To be valid, patients should have received sufficient information to include the nature, the purpose, the side effects, common and serious, of the proposed procedure, and for the treatments and management options, including the option not to treat and other options you cannot offer, and for each option, an estimation of likely risks, benefits, and probability of success. So 5 years before Montgomery, we've already got a pretty core text that gets lots and lots of doctors who aren't quite sure what to do. So where can I quickly find an answer, saying to them, you might want to do more than just say the common stuff. You might want to talk about the rare, serious stuff. I was also asked to tell you about what happens, the practical application. This is the slide, and this is the bit where my slight conflict of interest, no, it's not a conflict, my slight declaration of interest possibly comes into play, so sorry about that, but where are we at with general practice? How does this all apply to general practice? NHS general practice works at a limited budget. If you didn't know, we get probably, at best, about £150 per patient per year. We've got 10-minute consultations. We're delivering about 90% of patient contacts for about 10% of the budget. We're getting increased clinical responsibility as more and more things that used to get managed in hospital now get managed by the GP, diabetes, hypertension, heart disease, stroke, etc., lots and lots of it. Once the initial acute event has been dealt with by the hospital, we then carry on dealing with the long term. We've got increasing clinical responsibility, increased hours of work, increased stress. We're reducing how many days we're working, so you're doing all those big long days, but just doing, say, 3 days of it a week as opposed to 5 days of it a week, to try and reduce maintain the work-life balance, to try and reduce the risk of burnout. What does this lead to? It leads to an end of the personal list, so we don't have our own doctor. We have our surgery, but not our doctor. We don't have any cradle-to-grave care anymore. Patients don't, as they have their doctor, they have their surgery, and people are managed by a multidisciplinary team. You contact your doctor's surgery, you might see the doctor, you might see the nurse, you might see the nurse, the practice pharmacist, etc. It creates a really significant challenge, because when a GP meets their patient for the first time, and they've got 10 minutes to assess the patient from scratch, history, examination, investigation, thinking about a diagnosis, thinking about a management plan, what treatment might be suitable, trying to establish what the patient's ideas, concerns, and expectations are, so you can try and focus and tailor that management plan, describing the risks and benefits of any proposed treatment, not just the common risks, but the significant but rare risks as well. And you present that all in a manner that's appropriate to the patient's ability under capacity to understand, weigh up, and communicate that information. It's really, really difficult. The left-hand side of the screen is what we call the bell curve, or the Gaussian or normal distribution. And if you can read that bit, it's talking here about, on one side of this curve, this is about like, this could apply to anything, where you get a distribution of how things happen. And here it's talking about, on one side, a very small number of people who seriously underperform, and on the other side, seriously excellent performance. But in medicine, we don't tend to think about things like this. We probably tend to talk more about things being outside of normal range. And what we have here, at the moment, with general practice, is we're going to have doctors who overcomplicate matters and doctors who oversimplify matters. And those doctors who are going to struggle to perform, struggle to manage the clinical risk, the risk-adverse GP, who's concerned about the medical legal risk, is going to struggle to manage that consultation in 10 minutes. They're going to overcomplicate the whole consent procedure, giving too much information. They're going to overrun. They're going to struggle to document the consultation, protecting themselves. They're going to receive complaints from patients because they don't quite connect very well. They're going to get performance managed by their bosses because they're overrunning and they're not doing the work, and they're going to get burnt out. Okay? On the other side, we've got those doctors who continue to oversimplify matters. They don't give enough information. They take a doctor knows best attitude. They fail to elicit the patient's ideas, concerns, and expectations, so they don't tailor the care according to what the patient needs. They don't consider patient capacity. And the GP is likely to ignore Montgomery. They're going to ignore modern consent, and they're going to be exposed to complaint and litigation. That's what's going to happen at the extremes. In reality, most people are sitting in that big, big, big hump in the middle of the curve. And that's probably what's protecting us. So what are we doing in general practice? How does this apply? It's really easy, as I say, for surgical specialties and practical hospital-based specialties to think about consent for particular procedures, but what's happening in medicine? And I was having some conversations with a GP a few days ago, and he shared with me a couple of scenarios, and these are recent guidance given by the Medicines Healthcare Regulatory Authority in this year, 2023. And I'm going to start with the easy two, and then I'm going to talk about the more common, as my last one, big one. So fluoroquinolones are antibiotics such as ciprofloxacin, and in general practice, they are most commonly used to treat as a first-line treatment for epididymitis and prostatitis. So that's infections of the prostate and the epididymis. A reasonably rare infection, but if a gentleman comes in to see me in surgery with one of those infections, I'm going to be reaching for that as a prescription. But you will notice that the MHRA have said there's risk of suicidal thoughts and behavior. Now, if I'm going to give a drug to someone, and there's an incredibly small chance that it's going to cause them to feel suicidal and maybe do something suicidal, I think that probably reaches that threshold where I should be telling them. And that's what the MHRA are telling me. And they've got a fantastic big list of long things to tell my patients. And if I'm going to say to someone they might be feeling suicidal, it's not just them who need to know, it's someone else who might notice it, because they might not act appropriately on those thoughts. They might need someone else to observe and help them out with that. But there's a big long list there. What's going to happen if I, as a GP, have to start giving a patient all of that list of things to say to the patient? It's going to start adding time to the consultation. It's going to start adding complexity to the conversation. It's going to make things very, very difficult. The next one is nitrofurantoin. Some people might know of nitrofurantoin. Nitrofurantoin is an antibiotic. That's the first-line antibiotic for lower uncomplicated urinary tract infections, cystitis. And it has a risk of complications involving the lung and involving the liver. Once again, a bit of a list there of things on the left of what you should be saying to your patient about the risk of having, for example, breathing difficulties, or getting jaundiced, or getting pain on the right upper side of your abdomen. Again, think about how much time it's going to take for me to discuss all of these, to safely and appropriately hand it over, and then the time I'm going to get when the patient comes back in a few days and says, I'm feeling a bit breathless. Final one, statins. Now, there might be some people in this room who are taking statins. And Typically, we are well aware that statins might cause some liver damage. Your doctor, if you're prescribed statins, will tend to do some liver blood tests before treatment and then a bit later to check it doesn't cause liver damage. And it might cause some muscle damage. And they'll tend to talk to you about if you're getting aches and pains, you might need to come back and see me, ... But we're now told about a risk of myasthenia gravis. Myasthenia gravis is an autoimmune condition. It affects the neuromuscular junction. What that means is that it stops communication between the nerve and the muscle. And there's a muscle in your body called the diaphragm, and I think you know what the diaphragm does. It makes you breathe. So if you're going to get a loss of communication between the nerve and the muscle, and in myasthenia gravis, in extreme severe cases, it will lead to respiratory arrest, and obviously if you don't breathe, you're going to die. So again, we're told we need to warn people about this, on top of everything else. So the amount of time and complexity that it's going to add to consultations is going to be reasonably significant. So, in conclusion, I think there was definitely a gradual transition, as Jonathan said, as I've said, between that whole concept of doctor knows best to that patient-centered information decision-making, and that certainly has been taking place over the past few decades. Much of that, I think, was initiated by the medical profession, but I think cases like Montgomery have definitely also nudged things in that direction, and I don't say that's a bad thing. But I think the practice of medicine is a really carefully balanced consideration of many competing factors, and there's a wide range of differing practice. We know about Montgomery, and we know that some doctors will be quite defensive in their response to that, and others might choose to ignore it, and they may even survive their career without ever being challenged about the fact that they haven't taken consent in a Montgomery appropriate kind of way. I'm concerned that healthcare is under stress at the moment, and fully applying Montgomery, as I've explained, in every clinical encounter is going to be a significant clinical challenge. I think what's going to save us, in part, is the fact that consultation skills training and the way that we develop a relationship with patients and we think about ideas, concerns, and expectations and assess capacity and so on is what's somewhat going to save us from most complaints, but not always. Thank you.
Right, we're moving on to start our debate. Just to let you know a few of the rules of the debate. We're following MACE rules, apparently not extended MACE rules. Clearly you'll all know the difference. I had to Google it. So on one side we have proposing the motion, Charles Feeny, and it will be seconded by Dan Morris. Obviously, I think a lot of you know Charles. In terms of Dan, he comes from Bevan, Britain. He was instructed in the Supreme Court case of XX against Whittington Hospitals and the Court of Appeal case of Bilal. So that's one team. On the other side, we have Charles Austin, who you should all know, and a lot of you will know Helen Neville, who is from Bond Turner, and she's also a Deputy District Judge. I'm told to emphasise that the speakers are not giving personal views. They're obviously just putting forward an argument on behalf of each team. So please don't shoot them if you disagree with anything that they're saying. On that basis, I'm going to start in handing over to Charles Feeny, who will obviously explain what he is proposing and then give his arguments to support the same. If you'd like to start, Mr. Feeny.
Yes, thank you very much, Madam Chairperson. I'm sure you'll recollect during the First World War that Georges Clemenceau, the French Minister for War, famously said to Lloyd George that war is too serious a business to be entrusted to military men. Now, Clemenceau was a very combative character. His nickname was Le Tigre, the tiger. But during the First World War, he was actually 75 years old. So I think when he was talking about not just entrusting war to military men, he was probably doing it at a rather high-level sort of way. I don't think he was anticipating that he would get in the trenches with a tin helmet on and a rifle with a bayonet on it. Now, you might be wondering why I'm talking about that. Well, that's because, in my perception, nearly 100 years later, the Supreme Court decided that medical practice was too serious a matter to be entrusted to clinicians. And they did that in the case that I think you've heard quite a lot about now, called Montgomery. And they decided in that case that the law had to play a part, and I'm going to suggest to you a very detailed part, in standard clinical practice. So unlike Clemenceau, they did get into the trenches. And in proposing this motion to you, what I'm going to suggest is that they made a mistake in getting into the trenches. And whilst doctor knows best is obviously outmoded, doctors are not wholly separated from the rest of society, and that the approaches of clinicians was evolving in accordance with the expectations of society. Now, of course, law has a role in clinical practice, must do, to the extent that if you don't obtain consent and cut someone's leg off, I think it's probably an assault. If you cut off the wrong leg, that's probably a breach of duty. I might defend both claims, but I think that to be generally accepted. But the point about those examples is they're the laws operating in a very clear and straightforward way. Well, is it doing that in Montgomery? Well, I'm going to suggest quite the reverse. The rationale for Montgomery is autonomy. Now, no one can be against autonomy, can they? I mean, it's a bit like saying, you know, there shouldn't be crisp white snow at Christmas, or you think it's great that Bambi's mother got shot. You know, you're not going to come out and say, I'm against autonomy. But as stated by a judge in the Supreme Court of Israeli, and Craig directed me towards this because I don't often read the judgments of the Supreme Court of Israel, Mr. Justice Andrew Fang said, autonomy is a slippery concept. And when he said it was slippery, he didn't mean slippery in the sense of being dishonest or nefarious. He meant slippery in the sense of difficult to get hold of. I often say to clients in a difficult case, well, getting to grips with this case is like trying to get to grips with a wet bar of soap. And that's the sense in which slippery was being used. And the reason it is slippery in the context of Montgomery is because we don't really have a specific and clear definition of autonomy that we can take into day-to-day clinical practice. Autonomy, whilst it's undoubtedly a good thing and we'd all like to have it, is not clear in its boundaries. And I could go on some length about this, but I've only got 7 minutes, so I'll just give you one example, which is that discussion about autonomy says, does it protect all choices, or does it just protect valued choices? By valued choices, choices that actually will do you some good and will make you better, to put it simply. Whereas, does it protect bad choices? And if you take Montgomery in its most literal form, it protects bad choices. So it enables a patient to choose treatment which, in the doctor's reasonable view, is damaging, potentially damaging to the patient. So why should that right be protected? In particular, because that ramifies for other people. If I decide to, against my doctor's advice, to take a course of action which results in me becoming disabled, and I should say straight away I wouldn't do that, but if I actually did do that, I would then become a dependent person, I wouldn't be economically active, the state would have to pay for my care. So why should that right be protected? Then moving on from that, it doesn't work in practice, does it? Because we've seen that in 2 appeal court decisions in this year. That's the cases which you've been heard about, and I'm sure knew about as well, the McCulloch case and the Bolam case. In both those cases, the appellate court said that the autonomy principle, the Montgomery principle, doesn't apply to identifying reasonable alternative treatment. Well, why should that not be the case? Because undoubtedly autonomy is engaged in relation to reasonable alternative treatments in certain situations. For example, a surgeon might think that some new experimental surgery is not a good idea. So the surgeon recommends standard surgery. The patient does badly, picks up his or her copy of the Daily Mail next week and sees that there's this revolutionary new surgery out there. The patient may well think, well, why wasn't I told about that? Why wasn't my autonomy infringed in that situation?
1 minute.
Okay. I did ask her to do that, by the way, because you might have noticed that sometimes I don't stick to the script. But I will finish this now in 40 seconds. Just to give one other example under that head, supposing the patient's recovery from surgery is dependent upon of strict rehabilitation after surgery, which is often the case, and the surgeon forms the view, we're looking at this patient, they're not going to do it, so I'm not going to offer them surgery. And then afterwards, again, the patient does badly on conservative treatment and asks why surgery wasn't offered and says, well, it's because I thought you wouldn't comply with the rehabilitation. Hasn't the patient's autonomy been infringed in that situation? So that's a distinction that doesn't work. And the reason it exists is because there's a perception that Montgomery was, as the motion says, unnecessary judicial liberalism, which hasn't furthered clinical practice.
Thank you.
Clinical practice was developing anyway.
Oh, I don't know how to stop it now.
Very good. No, not you.
Thank you. We're now going to hear from Charles Austin, who is going to oppose the motion.
Right. Thank you. That was all very interesting and theoretical. But if we return to the actual proposition that's been put forward, there's two elements to it: that the decision in Montgomery was not necessary and that it hasn't assisted in developing clinical practice. Now, having just listened to everything that's been said, I'm not going to delve into the trenches or the First World War, but what I'd say is the summary of it is effectively that it's a complaint as to the regards and limits of what autonomy is. But the fundamental criticism, therefore, is difficult cases make bad law. But I would say to you that the limits and the theory behind Montgomery is in fact perfectly acceptable and indeed was necessary. The criticism as to the limits is simply based upon a lack of appellate decisions discussing the scope of application. Now, dealing then front and central with the proposition, there's three reasons why Montgomery was necessary in the first place. The first being that the law prior to Montgomery was contradictory. The second, that the decision recognised that there was a patient right to information and it correctly placed the court as the arbiter of that individual's right. And that is an interesting concept which chimes a lot with a lot of academic theories on the rights-based theories that have certainly been spoken about by Oxford academics, particularly Stevens. The final reason is a much more practical one, which Helen will deal with in more detail, is that the decision in Sidaway effectively was outdated and that the medical guidance did not reflect Sidaway, and it would be wholly unrealistic and impractical to have a legal test that did not coincide with medical guidance. Dealing first then with the fact that the decision of case law prior to Montgomery was out of date, you've all heard from Craig that the Supreme House of Lords even decision in Sidaway was difficult to understand. Basically, the majority, and therefore the ratio, did rely upon a Bolam basis. However, that was far from clear in and of itself. Lord Diplock was a very strict application of Bolam, unless, according to Lord Diplock, you were a judge and had learnt skills as a barrister that would allow you to ask questions. He didn't mention solicitors as well, which we'll leave that to a discussion at the bar. Lord Bridge, and with whom Lord Keith agreed, applied Bolam, but as you heard, sought to temper the application of Bolam by saying that there would be cases in which a risk was so clearly and obvious that it would be necessary for the doctor to tell the patient about it. But the point is, it's unquestionable that it was a decision based upon Bolam, and being a decision based upon Bolam, it put the medical opinion front and centre, and that was, by the time of Montgomery, an outdated practice that needed to be replaced. The decision in Pearce, as you've heard, did seek to limit a strict interpretation of Sidaway. However, in doing so, their opinion of the Court of Appeal was very much based upon refining the approach of Lord Bridge as opposed to really endorsing the opinion of Lord Scarman, who gave, as you've heard, a powerful dissenting judgment in relation to the reasonably prudent patient. Prior to the decision in Pearce, we had instances in the Court of Appeal where there was a very strict application of Sidaway and Bolam, as you again heard, in cases of Blythe and Gold. And then addressing Pearce, Lord Wolfe stated, it seems to me, sorry, I should say that before making this comment in the judgment, Lord Wolfe had specifically considered the decision in Blythe, and he said, it seems to me to be the law that if there is a significant risk which would affect the judgment of the reasonable patient, then in the normal course it is the responsibility of a doctor to inform the patient of that significant risk. Now, I would suggest that that's conflating two principles there, that of Bolam and the prudent patient. And the reason why is because of Lord Wolfe's having previously considered the decision in Blythe and the exception, and as was argued in Pearce, that it's Blythe that allowed the proposition that if a risk is so clearly obvious that it should be told on the basis that it would not withstand reasonable and logical analysis. So the state of the law, I'd say to you, was that if there was a significant risk affecting the judgment, then it was still based upon Bolam. That was a wholly unsatisfactory situation, and therefore necessary for the Supreme Court in Montgomery to put an end to a Bolam basis for the consideration and analysis of risks. It also had the added benefit of bringing UK law, and as you've heard, Scotland did not have the benefit of the decision in Pearce, in line with other Commonwealth jurisdictions, particularly Australia and Canada. And I'll finish quickly by saying that by recognising the autonomy of the patients and that there was a right to treatment, it correctly installed the court as the ultimate arbiter of an individual's right. It would be wholly inappropriate for the...
Time. You can have a couple of seconds to finish your sentence.
It would be wholly inappropriate for a medical professional to decide upon the limits of an individual's right. And that was indeed recognised by...
That's another sentence. Stop, please.
Lord Bridge in Sidaway. Thank you.
We now pass back over to the proposing team, and Dan Morris is going to give us another 7 minutes on why the motion should be sustained.
So while Charles has concentrated on the theory and the law, what I wanted to look at is, in practice, has Montgomery been this revolution? Has it changed significantly clinical practice? And I say, no, it hasn't. As we've heard, it's more of an evolution rather than a revolution. And I say that firstly because we already know that the GMC guidance that the Supreme Court relied on was there. That was a big part of the rationale of the court, and it relied on it heavily in Montgomery. But the second point is that the best doctors have always known that dialogue and discussion and debate and trying to tease out the patient's preference is what is required to make sure that you do obtain informed consent. The biggest revolution I would suggest in this area is the change that is coming from NHS England around shared decision-making and the requirements of that. Shared decision-making is exactly this process of discussion, debate, dialogue, with consent being the culmination of that. But I then want to think about, if it hasn't changed it in practice, could it really change it? And again, I say no, because what we have from the Supreme Court justices in Montgomery is a very ivory tower notion of what it is like to have these kinds of consultations and discussions. We've heard from some of our clinicians about some of the pressures that you can come under, particularly in general practice. There are time constraints, that is the reality. We have, particularly where I practice in London, large teaching hospitals with multi-ethnic, multicultural populations, which it is very difficult to tease out from those individuals what their preferences and priorities might be. So there are practical difficulties around that. And I think the Supreme Court justices in Montgomery perhaps don't appreciate what it's like sometimes, particularly in a busy NHS hospital. There is then the question of what difference has it made to patients? We know that some patients can refuse or not be interested in hearing all of these risks and alternatives and the variant treatment options that might be there. But I would suggest that many patients just want decent advice in the end. And I've practically encountered this myself. Just last year, I broke my neck and was given the option of having surgery or conservative treatment in the course of a neck brace for a few months. And I like to think that I know a little bit about this area, and I've met enough clinicians over the years to know the sorts of risks around this surgery in that part of the spine and around that part of the neck. But in the end, all I wanted was a firm steer as what was going to be best for me. So I saw a spinal surgeon. I took my imaging to a friendly neurosurgeon. He very kindly put it to the MDT clinic. And as you perhaps might expect, you had the 3 spinal surgeons in the clinic all wanting to operate and the 3 neurosurgeons saying they wouldn't. So, I mean, in the end, I think what I'm trying to say is you just want good advice. You just want somebody who's going to give you a firm steer. And finally, I think perhaps slightly treading on Charles's territory here, but it's this notion of what is autonomy. There are so many different interpretations of it. I think Craig will know there's a whole academic textbook on it, Belvedere and Brownsword, I think. And they talk in that case, for example, about the idea of self-creation and this core central sort of idea of privacy and personal choices. But in the French courts, we know there is the case where involving the dwarf throwing, the chaps who wanted to express their dignity and autonomy by earning an income in fairgrounds in the south of France and such. And that went all the way up to the highest court in the land. And it was decided that they did not have that autonomy. They couldn't have that right, notwithstanding that that is what they wanted to do, and they thought it would be a slight to their personal autonomy. I think that really is all I have to say. I'm a little short, but I will pass over to my opponents. Thank you.
And then finally, I hand over to Helen Neville, who is going to stand in opposition to the motion.
Thank you. So the proposition, let us just remind ourselves, is the decision in Montgomery is unnecessary judicial liberalism, which has not assisted in developing, and it doesn't say significantly developing, clinical practice. So I just read that as Montgomery was a waste of time, didn't change doctors' practice. Well, it was necessary. It has assisted. If it was unnecessary, why did the GMC and the Royal College of Surgeons update their guidance on consent and the consent process post-Montgomery? If it wasn't needed, why would they do that? We had the Royal College of Surgeons Guide to Good Practice post-Montgomery. It was created and designed to develop clinical practice post-Montgomery. Even post-McCulloch, these key parts remain relevant. They were to change a clinician's practice by helping them understand what was required post-Montgomery. So, for example, it says the aim of the discussion about consent is to give patient the information they need to make a decision about what treatment or procedure, if any, they want. It has to be tailored to the individual patient. Material risks, it talks through the test of materiality being twofold, looking at the reasonable person and what that individual person wants. This is all post-Montgomery. It changed clinical practice because the GMC and the Royal College of Surgeons adapted and modified their guides. If it's argued it was not new law and that these principles should have been known by doctors for many years, That's simply ludicrous because we know that's not the case. We know this from our own cases in practice. We each practice medical law litigation. We have these cases. I oppose the proposition saying that doctors were already doing this. We know from our cases that they were not and that they still aren't. I conducted group action for eye surgery patients in the High Court. These patients were elderly and vulnerable. No risks were discussed with them about how they might lose their sight in the good eye or how this medical treatment that they were being asked to consent to likely wouldn't change their vision. Montgomery gave these claimants legal recourse. Secondly, whose perspective are we looking at when we're viewing the issue and rights and obligations and the burden, and when we're looking at developing clinical practice? I say we should look at it from the patient perspective, not the doctor's perspective, or not just the doctor's perspective alone. What's the point of clinical practice if it's not to treat patients as individuals with unique considerations, aims, desires, and needs? The Supreme Court in Montgomery emphasised patients to be consumers. It is an individualised approach to care. That is what I define autonomy to mean. We've heard from the proposers that it's a slippery slope and that we don't know what it means. No, it means that it's an individualised approach to care. If there are now post-Montgomery detailed conversations and consideration of significant issues an individual may attach to something, how is that not a real and practical development? If the dinosaurs of the medical world have been post-Montgomery forced to look at a patient wishes and autonomy, that's a development for the good of the patients. If we know pre-Montgomery these discussions were not happening, Montgomery made it clear that these needed to be considered and discussions occurring is a development. McCulloch has not overruled Montgomery and the need to advise on material risks. Montgomery is still good law. Thirdly, this is not a burden. Do not be persuaded otherwise when you look at it practically. If there is a conversation to be had with the individual, so be it. If it adds on time, so be it. Why is that a burden on the doctor to discuss things? I say it would be a burden to be negligent, face litigation, have to do witness statements, have to do analysis reports, and the costs to the NHS in compensation and damages and litigation costs. That's a burden. If a GP or a doctor cannot explain matters in their 10-minute consultation, that's fair enough. Come back, make a follow-up appointment, tell the patient, I don't have enough time with you right now, I'm sorry, to discuss this in detail with you. I'm going to make you a follow-up appointment and it's going to be 20 minutes and we're going to discuss that. Furthermore, it is not a burden in scenarios where there's enough time to discuss these material risks. For example, in the case of Montgomery, there was time, there was opportunity for the defendant doctor to tell Nadine Montgomery about the risk of shoulder dystocia. The defendant even agreed it was a high risk. She believed if the condition was mentioned, all women would request a caesarean. So in that circumstance, there is no argument that there was no time to discuss that risk. There was. To ignore all instances like that is not correct. In any event, I say that a court would take into account the location, the urgency, the situation and the time pressures a doctor has on that day in question and then look at whether a follow-up appointment should be arranged. Lastly, why do they say that this is unnecessary and term it as liberalism? Is it really liberal to want to stand up for women and patient rights in general? I come at it from a societal aspect. How is it liberal to give vulnerable patients rights rather than being accepted as the norm? Why should women like Nadine Montgomery have no patient autonomy about her body and her own child? Who's making these decisions? We have the Donna Ockenden report covering a period of time pre-Montgomery and post-Montgomery. We know the risks and the consenting process should take place. How many maternal and fetal deaths would have been saved had these discussions taken place? We as lawyers play an important role in holding doctors and trusts to account, and by applying the Montgomery decision, we can do that, not only to change clinical practice, but to change the culture in the NHS. And for that change to occur, Montgomery, it cannot be denied, still has and will still assist us in doing that. Thank you.
I'm now going to open up to the floor. Has anyone on the floor got anything they want to say either for or against the motion? Yes.
I just wanted to comment on the opposition's point. And they mentioned the GMC guidance and Montgomery catching on with that. Is it necessarily the case that the law should match the GMC guidance? Couldn't we see the GMC guidance as something more aspirational and maintain a lower standard of care, but see this as something doctors should aim for rather than something they'll be sued for if they don't quite reach?
I think that's an interesting point, difference between aspiration versus breach. But what I would say in reflection of that is that the common law has always been in a position where past perspectives should not be indicative of a breach of duty. You can't look at a situation with rose-tinted glasses, as Lord Denning famously said. But that equally applies in reverse. And so if an instance which was so clearly had changed in the GMC guidance, if it had been a minor tweak, I would have thought your point might be a bit more valid. I'm not saying it's not valid, but I don't agree with it. And whereas this had been such a significant change that it's wholly unreasonable and impractical for the courts and the law not to be reflective of that. And that links back to the point I was saying that in this field, it should be the courts that are determining the rights and the limits of an individual's rights, as opposed to the doctors looking at what they considered to be an appropriate risk.
Any other comments or questions from the floor?
So, Charles, you mentioned the patient's rights. I think you said you used the phrase the right to information, and then you mentioned that the McCulloch doesn't overturn Montgomery, clearly. I guess my question is a bit broader in terms of where does that information come from? So, for example, as a clinician treating someone with, for example, a bad back, if you're trained in traditional Western medicine, are you obliged to mention the role of, say, osteopathy or chiropractic, which many people derive great benefit from, but as a Western trained doctor may be completely outside your area of expertise or knowledge? And then another example, which I'm sure people have had some personal experience of, is I'm sure there's probably not a single person in this room who's not been directed to a GoFundMe page for a poor child who's a friend of a friend of a friend who's got some nasty, horrible brain malignancy and is being sent a fundraiser for £400,000 to send this patient or this child off to a centre of excellence in Germany for vitamin C therapy. Now, I'm very, very cynical about those types of fundraising because I don't think there's any evidence to suggest that there are any benefit. But if you're a Western trained neurosurgeon faced with a patient who's got a dreadful terminal malignancy, should you be obliged to say there are people who've gone to clinics in Germany and have had treatment and derive benefit?
Well, I think that again this shows the unease between Montgomery and McCulloch, in that ultimately are we moving towards a position whereby assessing a breach of duty on a Bolam basis, does the reasonable doctor have regard to Montgomery, and does the reasonable doctor understand what Montgomery says? In relation to non-Western medicine, the point, I think, is that it would be difficult for a doctor or a surgeon who is aware, and this was discussed in length in McCulloch, and this is, I think, where the unease lies, is aware that there is a school of thought that a potentially new or alternative means of treatment could have benefit, but you would almost always find a Bolam defence to that. That is an uneasy proposition. It goes back, though, to an understanding of material. Is this effectively quackery? In which case I think you could be safe in disregarding it. Or would there be a clinical benefit from it? You used the example of a chiropractor. I've never been to a chiropractor, but lots of people seem to say they benefit from it. I think it would be dangerous, from my point of view, if a doctor did not at least signpost the possibility of alternative treatments. Whether or not that's discussed in full detail at that point in time would be a different question. But it does link to what Charles was saying about autonomy. And if you do approach it in a concept as broad as autonomy, there are always going to be instances that fall through the gap, which was what my ultimate criticism of the proposition is, that it amounts to difficult cases make bad law. The theory is right. The appellate courts need to flesh out the extent of the theory, is what I would say. I mean, do you agree with that, Charles?
Not at all.
Okay.
No, I think that example, I think, was consistent with one of the examples I was giving, that autonomy doesn't work in that context. So it goes up to it being a slippery concept. You can't make it some overarching concept if it doesn't work in the difficult cases. I mean, it's easy enough, isn't it, in the straightforward cases where, you're telling someone, if I do this, I'll save your life, and if I don't do it, you'll die. I mean, that autonomy is fine there. But in the difficult cases, particularly where people have a lot of medical information available to them now on the internet, and I'm sure you come across this, and they start asking you about all sorts of fringe treatments. So, I think it doesn't work in that situation, and I think a legal principle should be workable. I'd also like to pick up on Craig's point as well about aspiration. I think that's an important point, because I think Montgomery was basically aspirational. And yes, it has changed guidance, but you could argue the guidance has become aspirational now rather than practical. And again, is that really going to be helpful to people on the front like you two? Yeah. So.
I totally disagree, just so you know. Because if what Charles is saying is that we have these patients who are looking up all sorts of things on the internet, that would be taken into consideration. You've got a client there, a patient, who is looking at things on the internet. So, and I'm looking at this practically from a legal case perspective as a lawyer. It would be really difficult for them to then come and say to me, oh, I spoke to my doctor and he didn't tell me about this, when the evidence is that they've actually already seen that that's a potential treatment that they've looked up on the internet. So when we actually look at the practicalities of these things, I don't think it's as difficult as one says it is in terms of the implications legally. If you've got someone looking at osteopathy or chiropractic treatment that the neurosurgeon or spinal surgeon isn't going to recommend because it's not Western medicine, you would just be discussing, as you usually would, conservative treatment and their option to go of their own volition to an osteopath or a chiropractor or acupuncture. And yes, as I say, if you've got a patient who has all this information coming to you, they've already looked at all of that information, and then you're then going through what options they've got. It's going to be a case-by-case basis. That's what the whole thing is about. I've got a procedure on Monday. I know all the risks, which makes me scared of it, but I know that they're slim and I'm still going to consent to it, and I'm very aware of the consent procedures. Someone else going in for this procedure may not, may attach more significance to those risks, and that's just the way it is. But to deny patients the ability to assess their own risk and information is just wrong, I think. we're not stupid.
Well, for some people, patients. But,
Yeah.
I think for me the fundamental point is who, in our constitutional system, who should be making the decision? Is this something that the doctors should be deciding upon, or is this something that the court should be deciding upon? I think given where we are and certainly where we've moved to, even if the concept of autonomy is difficult, the net result is that the court is the the final arbiter on this issue, and that is, whilst it presents difficulties, that is the correct position to be, because otherwise you're slipping back into medical paternalism.
I think we're going to have to stop there, are we, or not? No? Okay, no, right, we're not stopping. We're carrying on.
Interesting. If we accept that good clinical practice already involved a subjective discussion with the patient about their own preferences and so forth, do you think that Montgomery could and perhaps should have been decided in the claimant's favour simply based on Bolam and Belitho? That's a question to both sides.
Yes, I do. I think what the consultant was doing there wouldn't be acceptable by reasonable clinical practice at the time it happened. I think the risk was very high, and it was a paternalistic approach, and there was plenty of evidence from which the court could have said, well, actually, that's just not on now, you know. And I think that developing clinical practice would make Bolam work better, because without being paternalistic, the doctors really know what they're dealing with in that context. And poor practice would be found liable without some aspirational, if I say it again, legal principle being necessary. So that's my view, but not everyone might agree.
I actually agree with him on this point as regards to the specific facts of Montgomery. It was a 9 to 10% risk. Whilst that wasn't binding, that was the type of risk that Lord Bridge had floated in Sidaway in any event, so that it was clearly negligent on a Bolam basis. But the Supreme Court took the opportunity to move the law forwards, which I thought is to be applauded.
Did you have one more point you wanted to come back on?
Just on the point of it should be the court deciding, couldn't we say, though, that judges only see patients where things have gone wrong and they're complaining, whereas doctors see the full range of patients? So why would a judge have a better idea of what the reasonable patient wants to know when they're only seeing a very, very narrow subset of patients, when the profession is seeing the full range? They might have that better idea of what patients want.
Well, the judiciary are guided by experts. It's just that the court makes the decision as to that finding. So the court would be guided by experts in that case, for example, in a case about what a reasonable person may attach significance to, the range of risks, significance of risks, and then you've got the witness statement and witness evidence from the claimant. So personally, I wouldn't think that a judge would be unable to understand that situation.
I also think there's a fundamental constitutional point here, which is the role of the court. And if you accept that the court is the correct forum to determine the limits of an individual's rights, then yes, the court should be determining that. As Helen said, they can always be guided by evidence, but the fundamental decision should be made by the court and not by the medical profession. There's probably a huge conflict between what the lawyers think is right there and what the medics think is right. But if you are unhappy about it, well, you can always write to your MP, kind of thing.
I think on that note then, we are now going to have a vote. Please don't vote for this side just because Charles got Le Tigre into the debate. Whilst that's very impressive, I don't think that should win him the vote necessarily. So if you could just have a show of hands as to who would go with the proposing motion that Montgomery is unnecessary and hasn't assisted clinical practice. Anybody? Oh, a few rogue hands. And therefore, am I to assume that the majority go the other way then?
You can put your hands up, just...
Wait, go on.
Yeah, thank you.
I'm afraid the motion is therefore denied.
Yeah, I think it's always said in Chester and Ashfar, the defendants won 2-3, with Bingham and Hoffman voting. So we're going to take it in that spirit.
That concludes the session today. Thank you for those who came and offered their assistance by talking or with the debate. Thank you very much. And thank you for everyone for coming and listening to us. I am told that if you'd like to stick around, there are some drinks in the Palm Court for everybody. And thank you to those online as well. I didn't ask how you voted, but I'm afraid we're a bit pressed for time.
That's good.
You obviously won all of their votes, Charles.
No, that's exactly.